Good morning and welcome to the Florida Supreme Court. Our first case today is number 2020-0529, Florida Bar versus Crowley.
May it please the court, I'm Scott Tosian, and I'm here with my client and co-counsel, Chris Crowley, in this case. We're here primarily today to ask the court to find that Rule 4-8.2a of the Rules of Professional Conduct is facially unconstitutional in its intent discrimination, and based on the cases that we cited in our brief, beginning with the New York Times versus Sullivan. And we don't dispute that the bar can ban defamation, but it has to be done under proper circumstances. And the cases that we cited all talk about a subjective recklessness burden to show that the speaker knew or should have, did know, or was reckless in its disregard for the probability that the speech was false. And the cases we've cited, again, starting with the New York Times versus Sullivan, in that case, they talked about how important speech that deals with public debate is under the First Amendment, and that it's a core subject for First Amendment speech. And in the New York Times, they said that the public issues should be uninhibited, robust, and wide open, and they may include vehement, caustic, sometimes unpleasant attacks on government and public officials. And that's what we have here. We have somebody running for state attorney and was the chief assistant.
Would you concede that if the election were a judicial election, you'd have a harder argument to make here?
There's no question about that. I mean, the Canon 7 of the Code of Judicial Conduct doesn't allow any type of repartee between the...
And would you further concede that, or would you argue, I guess is the right word, that if this were an election for state representative, you'd have an easier case? Or do you think that your election for state attorney is equivalent to a congressional or a state House race in terms of the constitutional issues that attach?
I hadn't thought of it in those terms. I think it's definitely... There's definitely much more protection, First Amendment protection, in a state attorney race, because the state attorney
than in a judicial race.
Yes, without any question.
But there is, I think, an acknowledgement in our jurisprudence on this, not at the U.S. Supreme Court, and we're sort of now far afield of New York Times versus Sullivan. But if we start talking about what we've done, both in Ray and in other cases, we've privileged the legal offices like state attorney because they are officers of the court in a special way, because the impartial administration of justice by a state attorney is a compelling, I think, would you concede that that's a compelling interest for First Amendment purposes?
No,
you don't.
We do not. No.
Okay.
Absolutely not. And the reason we don't is because the state attorney is a public figure, and under the reasoning of the New York Times case, those people have... But
so are judges, right?
I'm sorry?
But so are judges, right? Judges are public figures.
They are, but I would submit to you that judges' impartiality is more important than a state attorney.
Really?
I think it's a fact. I think it's a reality that they are more impartial than the state attorney.
Let's dissect that a little bit. Okay. Yes, I would agree with you that the job of a litigant, a litigator, is to make arguments for one side. But that's not the relevant definition of impartiality. The relevant definition of impartiality is the prosecutor going to prosecute crimes by friends and foes alike? And that, I think, is a pretty core concept. Wouldn't you agree?
Yeah, it absolutely is a core concept.
So then how is that not a compelling interest?
Because when the state attorney, at least in my circuit runs, they talk about law and order, law and order, law and order, and it sounds much like it's pro-prosecution and pro-law enforcement. I mean, that's the platform that they use to run. And so
well, they are prosecution.
Well, that's true. And I know that they're bound to do justice, not just to get people found guilty.
To sort of use the facts of this case, The concern would be that, for example, a prosecutor a candidate who makes statements about his opponent being associated with the PLO or being a proponent of Sharia law, one might see, if one were a voter of certain religious backgrounds, that cuts one way or another. In the same way that if a judge had made those statements, a litigant of certain religious backgrounds might say, I'm not going to get a fair shake from the prosecutor, from the judge. I guess that's my point, is that to me, that is the question on which you're looking for impartiality. And the reason I care is because if it is the same compelling interest, then I can use the line of precedent that tells me, okay, now we're talking about, is it narrowly tailored? Now we're talking about, is the bar rule narrowly tailored, where I think you have a better argument.
It's partisan political speech. I think that's the key to what you're deciding here today. This judicial speech isn't partisan. They're muzzled. Anybody that's run for office as a trial judge knows that. You can't say anything. And as a prosecutor, you can campaign, and the public needs to know. And that's another problem with suppressing speech in these types of elections, is the public needs to know what the qualifications of the two people are, and the second person that's running, the opponent, has every ability to do exactly the same thing, and that is, give a counter argument to what's been said about them. In this case, Mr. Crowley never said that she was a Palestinian or that she was a Muslim or that her religion was in any particular way. He posted a very small part of an article, and that was conflated into him.
Why don't we focus on the conviction rate for a minute? So the statement is clearly false, that her conviction rate is 39%, right? You can see that that's a false statement.
I don't think it was ever shown to be false. I think that there were issues raised about it, that it included, the percentage included the fact that there were a certain number of withholds of adjudication in certain cases that started in 2016, didn't finish in that year. So there were issues raised as to the validity of that, but I don't think it was proven that it was false. And what
did the referee find?
I think the key factor here is we're entitled.
What did the referee find?
Well, she found that it wasn't accurate for sure. I mean, I read part of the report again this morning. There was a lot to read.
Are you asking us to revisit that factual finding?
I'm sorry?
Are you asking us to revisit that factual finding?
Not so much that as to impose the recklessness standard before deciding that there's a violation of the First Amendment. That was not done. Clearly was not done. And one of the things, the referee found a lot of things, which in our brief you'll know that there was a lot of contrary evidence that she didn't accept. And I know that's what judges do. They accept this or they accept that. But it was across the board accepting what Ms. Fox and the people who testified on her behalf said, including the idea that she was not involved in the arrest and prosecution of Mr. Crowley, which strains credulity. If I was running for state attorney and my boss decided to prosecute my opponent and didn't confer with me, that would be shocking to me. And he also, when he did that, he said to FDLE, please expedite this. So, the referee found against us. There's no doubt. She didn't employ the proper test to all of the evidence. And we had the additional issue of her campaign treasurer being the same campaign treasurer who worked for AMIRA FOX. And when you take that fact, that wasn't disclosed, we found out after the hearing, and you look at the fact that on every disputed issue of fact, we lost. She didn't acknowledge, for instance, that a witness testified that AMIRA FOX was campaigning on state time. AMIRA FOX admitted she had to return $1,500 to the state for taking excessive leave time. There was no comment on that, and potentially that would indicate corruption. So if you impose the recklessness standard against what was said, you come to the conclusion that it wasn't reckless. It was not with the disregard as to the truth or falsity of what was said. Okay, moving on. I mean, that's the core of our argument, that we're entitled to the New York Times standard established in Garrison, established again in Counterman more recently, the recklessness standard, because there's never been a case in Florida like this. It's partisan political speech involving a lawyer's license. This is a case of first impression in the state of Florida. And there's nothing, I mean, I know many cases have said there's no distinction between regular political campaigns and judicial campaigns, for instance, although we know that there is a distinction. And in this case, it's a state attorney race, which is totally, it's totally different.
Counsel, if this were a situation in which the person was misleading the public, recklessly, intentionally, under that standard, not necessarily about their opponent, but about a factual issue in a political campaign, but just misrepresenting, we could say a fact or a theory or whatever, would that violate the bar rules if they're an attorney and they're misleading the public? They're making statements that are being quoted in the newspaper. They're being interviewed on a radio show.
And those statements are false?
I would say a reckless disregard for whether they're true or false.
If you employ the standard under New York Times and it was found to be reckless with no regard for the truth or falsity, I mean, I think we'd lose on that count. But
what about misleading?
Misleading? I don't think so, because I think that the whole idea of the First Amendment giving breathing space to political speech, it's got to be something that's pretty, I think, pretty severe. Otherwise, the First Amendment doesn't mean anything. Talk about the SLAPP statute, which was not employed in this case, and 768 has no prohibition against Florida bar matters being excluded from that, and it specifically was promulgated to protect people's right of free speech. And again, this case is really a case of first impression, all the way across the board, as far as I can tell. I've only been representing lawyers for 42 years, so I may have missed something along the way. But this is so much different from judicial speech because of the partisan nature of it, and because the person on the other side has the ability to communicate and counteract what's been said. Finally, on the issue of the penalty that was imposed, there's no precedent for that either, because this case is unique, and 60 days is just not in line with what should be done in this case. I know the bar cited the Avon case. A prosecutor ran for judge and maligned his opponent, and he got a public reprimand. The court said, henceforth, you're on notice that it could be worse than that in the future. But of course, the Avon case was, I want to say it was in 21. I tried it, actually. I think it was tried in 21 during COVID, and so it wasn't out there as any type of instruction to someone running for office. And that's, it's another part of why the penalty is too harsh. In judicial cases, judges have Canon 7. They have plenty of guidance. Before they run, they go to the meeting with the JEAC, and they get told what they can and cannot do. There's no such guidance in this case. We have a 28-year service member who prosecuted for 15 years, no prior discipline whatsoever. And the case is really an admonishment case. And I'm reserving the last minute for my co-counsel. Thank you.
May it please the court, I'm Mark Mason, excuse me, here on behalf of the Florida Bar, and I'm joined by paralegal Melissa Howland. We're here today not because of distasteful political rhetoric. We're not here today to punish someone for voicing an unfavorable opinion. What we're here today for is because Mr. Crowley leveled several false statements accusing his opponent and a race or state attorney of corruption for various reasons. I believe the referee's report, the first one, goes through 7 of those reasons, and found in every single case, none of them had an objective factual basis. The argument that this is violative of the First Amendment, that was fully addressed by this court over 20 years ago in the Ray opinion. Issue in this case is not whether this would withstand in a defamation action. I'm not here representing his opponent in the state attorney race seeking redress for defamation. The compelling interest that we are promoting here, that we are serving here with this rule, is to instill public confidence in the integrity of the legal system.
Would you concede that if he had been running for governor and was a member of the bar and made these statements about another lawyer, his opponent in the race for governor, that this would be a different case? And if so, how would it be different?
Likely would be a different case, and I only say that because the rule specifies who, these class of people who you cannot disparage without the objective factual basis. And it's candidates for legal office, and for a governor you don't have to be a lawyer, unlike a state attorney or attorney general or public defender, which is quintessentially that of a lawyer.
So the bar's position essentially is that we should treat this election like, is there any way in which it's not like a judicial election? Is it, or should we, for the purposes of Ray and the rest of the First Amendment cases, is the bar's position that this is identical to a judicial election?
The latter, and I say that because the rule 4-8.2a, it specifies all these classes of individuals, and it groups together judicial officers with candidates for legal office, with members of the jury. All of that is grouped together. So how do you go through this rule, this very short rule, and in this court in Ray says it's an objective factual basis test under 4-8.2a, and then start parsing it out further and say, well, no, for this person it's going to be an objective test, but for this other person it's going to be a subjective test.
So the bar's position would hold the attorney general race to the same standard as a judicial race?
I think it would apply to any candidate for legal office. However, that term ends up getting defined in subsequent case law, although I do admit under the Florida law I've only seen written opinions in the context of disparagement of judges. But I don't think that's really a distinction that bears any materiality here when you have the plain language of the rule that says what it says. And I think there's a good basis for it. The compelling interest isn't just, you know, we want to protect judges from criticism. We're not trying to protect the person who is the judge. We're protecting the robe, essentially, how people view that title, you know. And
but,
so,
but
yes.
part of the reality here is that judges are in a different category. In Florida, we don't have partisan elections. There's a whole different realm of things related to judicial elections. But then you've got these partisan elections for state attorney and for attorney general. And it just seems like that having the same kind of rules in both is a little odd. Just given the different constitutional interest in that are operative in partisan elections, where where the parties are involved potentially, and the parties may be. You say, is a candidate going to be responsible if the political party with which the candidate is associated comes in and does something that doesn't meet the standard that would be okay, that would be applied in a judicial context? It just seems like it's a very complicated thing when we move it over from the judicial context into the context of partisan elections for attorney general. So everybody running for attorney general in Florida has got to be worried about if they make some little misstatement or some exaggeration, that is going to result in them being in trouble. I guess that if once they're attorney general, they can't be in trouble for a while. Under the way that works, they have to wait till they get out. But it just, I don't know. It just tell me why my anxiety over that is misplaced.
All right, I'm probably not going to hit every subject you just said because that was a lot to follow. I'm going to do my best. All right, well, first off, the idea that a candidate's going to be responsible for what their political party might do. That's not the case here. And to isolate that further down, for instance, there were these political mailers that were put into evidence, 2 that were specifically approved by Mr. Crowley, and then 2 others that were issued by a PAC. He wasn't held responsible for what was in those ones that were issued by the PAC without his approval. So we're not holding him responsible for that. As for the notion that we should treat this differently than we would for a judicial officer, you know, this court said, and this is way back in 1952 in the Gluck case, which I cited in my brief, that the state attorney is a quasi-judicial officer of the court with the duty to see that a defendant gets a fair trial. Now, is that remarkably different? I know obviously it's a position of advocacy. You're trying to get someone sentenced or what have you. But it's still kind of the same, a very similar concern as what you're looking at when you have someone like in the Jacobs case that was just disparaging judges and calling them corrupt and saying they took bribes and that kind of thing. So the concern is not substantially different when you're talking about a state attorney or a public defender, because it all goes together. And in the comment to the rule, they even applied it, there's a comment about members of the jury, because the concern is, well, if you allow these kind of statements about members of a jury, that could really cool people in the future from ruling a way that might be deemed unpopular if all of a sudden these lawyers, who are viewed as having this high vantage point with a better understanding, are going to say that a member of the jury is stupid or corrupt and took a bribe to settle the case.
And so you view this as being limited to factual statements, right?
Factual statements,
it has to be
correct.
sort of by definition, to be encompassed within what's covered by the rule, it has to be, the nature of the statement has to be a factual statement.
It has to be a factual statement. Now, there could be an issue.
So it does, okay.
Yes.
So how does the bar understand factual statements that go to qualifications or integrity?
Well, a factual statement in this case would be AMIRA FOX is corrupt. That's not a statement of opinion. It's not.
I mean, I don't know if I agree with that. But let's focus on how you define. It seems like there are broad and narrow, relatively broader and relatively narrower ways to read this language.
Sure.
And so if you focus on, you know, if it has to be factual and it has to be, like, it's hard for me to understand in some ways, you know, a factual statement about someone's integrity, how that categorically, that seems like that would be a relatively narrow category of things. Qualifications, if I said, you know, they failed the bar 4 times and that's not true, something like that. I mean, how do you define the universe of statements that are even potentially covered by the rule?
Well, one of the cases I cited in my brief is kind of indicative of when it talks about that interplay between something that is an opinion and something that is a fact, and that was Milkovich. And the example they used was, in my opinion, John Jones is a liar, right? It's a mixed statement of fact and opinion, because, yeah, the beginning of it says, in my opinion, but then when you say John Jones is a liar, you're implying some deeper understanding, some deeper knowledge.
You're just implying an assessment. I think if maybe the cleanest test case for this is the conviction rate, right? Like, either her conviction rate is her personal conviction rate is 39% or it's not, right?
Right.
Okay, that's a statement of fact, you'd concede, right?
That is certainly a statement of fact.
So if we focus on that one, and if we sort of filter that one through the same analysis that the chief is walking through, if this were an election for not a state attorney, if it were an election for governor, and that sort of clearly demonstrably true or false statement was made, what would the bar's position be in that case?
I doubt it would violate 4-8.2a, only because you're not talking about a candidate for legal office at that point. It could violate 3-4.3, which is another rule he was found guilty of violating, because that prohibits misconduct that is contrary to honesty and justice, which would be cause for discipline. So the question would be, does that statement rise to that level of being contrary to honesty and justice in that circumstance, is how I would answer that question. And then the other part of it, which is part of my cross appeal, is the 4-8.4d violation, which he was found not guilty of, to be clear, and we're appealing that on cross appeal. because that says it's conduct in connection with the practice of law that's prejudicial to the administration of justice. So in terms
Is that rule narrowly tailored?
that rule is narrowly tailored. There's no argument to the contrary. The narrowly tailored argument is strictly related to 4-8.2a.
Is 4-8.2a narrowly tailored?
Yes, and I say that because when you're talking about overbreadth of a rule, the case law on that, specifically this court in Williams-Yulee, and then the U.S. Supreme Court on appeal said overbreadth has to be substantial for it to be facially unconstitutional. And the rule has been decided in Ray that we're going to use the objective test, and it's just been applied consistently since then with the objective test. As recently as, I think 3 months ago, this court issued an opinion in the Florida Bar v. Malik Lay, which said you need an objective basis before you disparage a judge. So with regard to 4-8.4b.
Why is it narrowly tailored, though, without distinguishing between judges and, call it, more policy-based and partisan offices? Why is that not enough alone?
Sure. It's because of the compelling interest that's being served, which was public confidence in the integrity of the legal system. That's what the court said in Ray, not in judges. It was, applied in the context of someone that was disparaging a judge, but the compelling interest was broader than that. That's why it's narrowly tailored, because you're talking about people, mediators, arbitrators, jurors, people who are integral to resolving cases. You're talking about the quasi-judicial office of state attorney who's assuring someone gets a fair trial, and obviously you're talking about judges. All of that, and it's only applicable to members of the bar. We obviously can't regulate lay people unless they engage in unlicensed practice of law. The rules are never going to apply to lay people. So it's narrowly tailored because of the context in which we're talking about this in, which is disciplinary proceedings. And just as a final note on my cross appeal, I cited cases, I'm going to try to save some time for rebuttal, about this being conduct in connection with the practice of law. And I say that because that's required to establish the 4-8.4d violation. He did it in his capacity as an eligible candidate for a legal office. What he was doing was trying to attain the highest position you could as a prosecutor in the 20th Judicial Circuit. That's sufficiently connected to establish that rule violation. And with that, I'll save the 2 minutes for my rebuttal.
I just want to say thank you to all you justices for giving us oral arguments in this case. I know that's discretionary. My name is Christopher Crowley. I'm the member of the bar who's at question here today. I just have some brief points because I only have a minute. I still stand by the 39% conviction rate, and the woman, the member of the bar who's at question here today. I just have some brief points because I only have a minute. I still stand by the 39% conviction rate, and the woman I ran against, nice lady, she was the chief deputy under that. I had an expert testify, former chief of computing. When it comes to this religion issue, publicly I stated, I don't know my opponent's religion and I don't care. Some other people said some stuff, I didn't. Okay, just to clarify those facts. When I joined the Army in 1995, I took an oath to defend the Constitution of the United States. Now the Florida bar says the Constitution doesn't apply to Florida attorneys. That's the way I see it. That's the way it should be, and that's the way I'm asking this court to see it. Effectively, the Florida bar is saying the First Amendment rights don't apply to Florida attorneys in partisan political elections. Yes, we're talking about quasi-judicial. This was a partisan race. I lost in a Republican primary. I wasn't running for judge. I'm asking the court today, you justices, respectfully, to stand up for free political speech. Remember first-year law, strict scrutiny? Okay, everything I said I believed in, I backed up with facts. Okay, we even brought many witnesses to show what I said was true, many articles to show what I said was true. I believe what I said was true. I understand that the referee didn't, but the referee had a conflict of interest, respectfully, that she admitted to. Okay, I'm asking the Florida Supreme Court to support and defend the Constitution of the United States. I thank you for your time. I spoke very fast. I'm a little nervous being up here, forgive me, but it's a long record, it's a long brief. I would ask you all to look at the facts of the case, because we actually put on more evidence at the referee hearing than the bar did. We brought in witnesses, we brought in articles. I believe if you look at all the facts, if every justice looks at all the facts, you should ask what we're doing. And I thank you for your
Could
time.
you just give us the 30-second version of the 39 of the your argument on the conviction rate thing?
Yes, witness William Smith, who testified at the referee's hearing, who's the former chief of data and computing for the state attorney's office for the 20th Circuit, he got it together, and we looked at all the arrests versus all the adjudications of guilt in the circuit. Now, there's a big debate about do withholds count, do diversions count, but we said over several past years, like I said, I went to an expert first on this, sir. Okay, I just didn't make it up. And it's a big debate, but that's what campaigns are about, sir. So, I'm sorry. I don't mean to be disrespectful. We looked at all the convictions versus all the adjudications of guilt, and that's where we came for the past 2 or 3 years or 4 years past. And I said that my opponent was the chief.
For the office.
Yes.
For the office. And so basically your theory is that because of her high position in the office,
exactly,
that, you know, she's responsible for the activities of the office.
That's what it said on her website, that as chief deputy, she effectively was the chief executive officer. And when we were campaigning, and I don't blame her, she was bragging about how she ran the office all the time. We went to hundreds of forums. It's a 5-county area. So I said, yes, you have a 39% conviction rate. And I did it in good faith, sir. And I believe it, and I believe it today. And I went to an expert. We actually pulled those numbers from the Florida administrative courts, and we went to a couple counties that provided it as well. The county numbers were very similar when you look at adjudications of guilt over, I think it was a 4-year period, I forget. It's in the testimony of Mr. William Smith. But we came up with the 39%, and yes, I stated it. And we had big debates about whether it was 39% or 85%, but this was a debate that was done in good faith. It was not a blatant lie. I didn't blatantly lie about anything. So there were some independent groups that did some stuff that I was not privy to. I don't think I should have to take ownership for those. Okay? And we even objected having those put in evidence. But I'm asking this court, respectfully, to please stand up for the First Amendment. Thank you.
Mr. Crowley said, I don't know my opponent's religion and I don't care. One of his mailers that he approved said, Fox refuses to disavow her direct ties to the PLO terrorist organization and she won't answer questions about Sharia law. I don't see any reasonable reading of that doesn't put her religion at issue.
What does that have to do, though, with qualifications and integrity?
It has to do with her integrity because he was implying that she was interested in attaining higher office to enforce Sharia law. That's why he shared the American Thinker article that said that.
Like, I'm not sure. I mean, part of the problem is that this rule is obviously the core part of what this rule is getting at is not really, obviously it addresses candidates, but I mean, the main part of this function, the rule is not really, it's not written to govern campaigns. I'm not saying that it doesn't apply, but we're talking about applying it in a setting that's sort of at the periphery of what it's for, and it's written to cover factual statements. We obviously know that in campaigns, I mean, most of what you're talking about is either debatable fact or opinions or mixed or whatever, and then it's even narrower than that because it goes to qualifications or integrity. I don't really know. It seems like if you read integrity the way you do, that would sort of just swallow up. It's really not a limiting word.
Well, first off, I don't believe that this case really does fall on the periphery of the rule if the rule specifically applies to candidates for legal office, and then the comment specifies further that that applies to prosecuting attorney. That seems to be wholly established by the plain language of the rule.
I mean, you don't think that the main point of this rule is to address things that are going on in the context of litigation? You know, the judge is this or that, the jurors are this or that, my opponent, you know, my opposing counsel is whatever. I mean, we don't need to get into a debate about that, but it just seems like you're not. There are things. I mean, this is a hard case, just in general, but it seems like the bar's view of it makes it even harder by not sort of reading the words more naturally than, I mean, I understand prosecutors sort of expand the, you know, prosecutors push the boundaries of the words as far as they'll go, but it seems like there are more sort of naturally sort of limiting ways to read some of this stuff that would take some of this stuff just off the table completely.
The way the bar has interpreted this rule is to apply it equally. So if you have, we cited DuPont, we cited Jacobs, both of them were 91-day suspensions, both of them involve similar conduct, and if the main factual distinction is, yeah, but that was against judges, this one was against a candidate for state attorney, that's just not a distinction that's referenced in the rule. When this court says objective factual basis test in Ray, it was applying it to the whole of 4-8.2a. So the bar just treated it the same as it would if he had disparaged a judge under those exact same circumstances. Recognizing he's never had prior discipline, but he refused to acknowledge wrongdoing, and this involves dishonest conduct, we are seeking the minimum amount of time you could have for rehabilitative suspension, which is 91 days.
And what's your, having heard what he said about the 39% thing, what's your response to that?
The 39% statistic is false, and
could you just specifically respond to what he said?
Sure. I'll address what he said. What he did was he took total arrests in Lee County for calendar year 2016, and he compared them to total convictions in that same county. That's not going to establish AMIRA FOX's conviction rate. Those aren't all the cases she handled. It presumes that...
Well, but you're ignoring what he said about her position in the office, and it is not an unreasonable thing to say if you claim responsibility for running an office, that you get the blame for things that aren't going well in the office. I'm mystified by the blindness to that, quite candidly.
The blindness to it, it's not blindness. What it is he took total arrest. So he's presuming that every arrest should result in conviction. That's what you mean. That's what it means when you take that number and you divide it by convictions and say she dropped the ball in these other 61% of cases. There could be a million reasons that there wasn't a conviction, and it doesn't have to do with the office failing.
Okay, we're talking about different things now. You're talking about one thing there, but you're talking about this not being her conviction rate, right?
Right.
And so you think that because it's not her conviction rate, then that it's some more global number, and we can argue about the accuracy of that. Okay, that's a separate issue. But you think it is somehow he's violated his duty when he attributes the performance of the office to her because of her position in the office.
I think that's one aspect of it, and the other aspect is...
I have real trouble understanding that in the context of a political campaign where... that just flies in the face of a lot of a tradition of the way campaigns and the First Amendment works in this country.
I understand the concern, but I would also just point out that it's not even a conviction rate that would apply to the office generally. It was a false figure, even if you're viewing it in that lens and then attributing it to her. Either way, it was false.
What should the numerator be? Number of cases indicted? Number of informations filed?
It's hard for me to really just establish how he would calculate that figure, because very frankly...
He has to, though. I mean, if you're going to accuse someone of making a false fact, there's the issue of what's the universe? Is it just her personally, or there's the office? But then now you're kind of making a technical point about how we're supposed to, like, what would the listener understand conviction rate to mean? And I would think that if you're going to prosecute someone for making a false factual statement, there would have to be some sort of understanding as to what is the quote-unquote fact that we're talking. What is the factual sort of measure of this, and is this false in relation to that standard, right?
Well, what I think the issue is he's calling her corrupt, and he's offering that as an objective factual basis to say she is corrupt. And the case law in Ray is...
Now you're mixing other stuff in, and I'm sorry, I didn't mean to talk
That's the
over
same
you.
point.
No, I don't think I am mixing anything in when he says that's a reason she's corrupt, because under Ray it says when you make a disparaging statement, the burden, we just need to show it was disparaging.
Now you're saying disparaging statement. I mean, this is false. This rule applies to false statements about people's qualifications or integrity. So I don't even know corrupt. To me, I don't even know if that's what does that even mean to call that a factual statement?
He even put in his brief that it means impairment of integrity. So I think that does apply to the factual basis with a 39% rate. That's the part that he is offering as a factual basis to say she is corrupt. That wasn't just a defense in the bar proceeding. He was saying that throughout his campaign as one of the many reasons that she was corrupt or that she orchestrated his arrest. All these different bases that didn't have any basis in fact. And very frankly, the burden was on him to establish that he had an objective factual basis. The bar just had to show that he made those statements that were questioning her integrity or her qualifications, and then he had to establish the objective factual basis. That's the burden shifting standard under Ray.
Okay. It seems like you should have to establish that something's false first before someone then has to defend themselves.
This test under Ray was that we present evidence that the statement was made and it questioned her qualifications or integrity.
So you don't have to prove that it's false.
He has to offer the objective factual basis. That's
okay.
The test.
We probably need to look at that.
All right. With that, I see I'm way over my time. So thank you, Your Honor.